Testing 1 2. Testing 1 2. Testing, testing. Testing, testing. All right. All right. Give me just a few seconds and everything should be a go. Also got my agua. So let me do this too, because this is crazy. All right. All right. Thank you for tuning in. Don't forget that supporting the channel is not a crime. Hit that like button and let's keep going. Let's keep growing. And while I do that, bang, there we go. All right. Now, a lot of times, you've seen the title, and a lot of times what people do is they don't understand the context in which I say a lot of stuff. And one of the things is I'm teaching Latin in law because simple principles are established through Latin terminology. Now, I say them incorrectly all the time, but I spell them correctly. So that kind of helps you out. And today, I'm probably going to say this incorrectly, but it's spelled correctly for you. And it's Decisis. It's the chessboard of legal precedent. Now, most of us have no real clue that it's Latin. We just know it's law. But it is Latin, and it means to stand by things decided. Now, the enduring principle of stare decisis is explored through the strategic lens of a chessboard. It's going to reveal how past legal decisions shape present and future rulings. The complexity of legal precedents is impacted on the American justice system and are unveiled. Now, what this does is the enforcement of legal decisions. Because a lot of times, one of the examples is Terry v. Ohio. We talk about that in the context of because what's sad is there are, I want to say it's 5 or 7. I've actually done a couple videos on it. But there are actually 5 different principles in Terry v. Ohio. Most common one is the stop and frisk. That's where it's mostly applied, or the actual police encounter. But most people don't understand that there's another element which is called the I went blank right then. It's where a police officer cannot use a hunch. They actually have to have evidence in order to go into a different aspect of a stop. And even an officer giving you, because this is where I always tell you, they don't have power because they are in the form of a servant until there's a crime that they can articulate, which is if they give you commands like go over there and sit down on that curb. If you do that, that is a show of authority stopped, and that is illegal. That comes from Terry v. Ohio. But again, most people are not taught that. And that is part of stare decisis, because clearly established is Terry v. Ohio because of the time frame. This is also one of the ones where I look to enforce legal precedent. being or equal protection. Now, this is why you have to learn your opponents because of the stare decisis or legal precedent. I was in front of a judge one day, and it was just happenstance, and it was a judge. He was in the news because he had a police officer who had violently beat a man, and this was in DeKalb County in Georgia, in Atlanta, and just so happened what he did was he lowered the charge to simple battery. He then gave the officer, I want to say 30 hours of community service. It was something simple, but it was definitely not the same thing. And I had a young man who went before this exact judge literally days afterwards. So the proposal was the exact same thing. Dismissal, or because the young man didn't want to fight more than he had to. And when the judge attempted to deny it, I told him, I said, well, slide this up to him. So when he slid it up to him, the judge was impacted and emboldened because he was upset because he had to go by what legal precedent he had already set on a prior case. It was his ruling. So how is he going to go against his ruling without undoing a previous one? This is why these things become important, because now you make them enforce the laws and decisions that are already made before you. And these are the things why you have to learn these cases, because even one I'm going to talk about later, it's one of those where in Georgia and pretty much in any state, you have the right to resist an unlawful arrest. Now, it was reintroduced in Georgia in 2021 by the Georgia State Supreme Court because you do not have to participate in an investigation. You do not have to. You're not. You know why? Because this pesky amendment called the Fifth Amendment, allowing you the right to remain silent and to protect yourself against criminal induction for the most part. I don't have to give you evidence against me. But again, why? Legal precedent. These are the things that you need to understand. And the application of them becomes greater when you do understand this and how they apply to your situation. And even the core concept, courts must abide by the core concept. Courts must abide by previous rulings when handling similar cases, enduring the stability and predictability of law. Now, a lot of times, because our legal system doesn't work as it should, we get frustrated because we don't know how to block or box someone in, like the prosecutor, or box the judge in on their previous decisions. So we become frustrated when they don't follow legal precedent. So that's where you have the out-of-town shooter. That will be myself. Well, I would advise you on how to set this up to lock them in and also force them to use legal precedent, the ones that have already been set. And if they choose not to, because that's what it is a conscious choice. They're choosing to become co-conspirators. They're choosing to not follow the law. They're choosing to conspire against. They're choosing. Now they're accepting liability through their choices and their actions. Now, in the Supreme Court, their decisions are binding on all lower courts. I'm going to say that one more time. Supreme Court decisions are the law of the land. They are binding on all lower courts, not just some, not just a few, all lower courts. So that's why you also have these certain things, and then there are tricks that you can also kind of employ. I'm going to start uploading those videos on next week But these are the things that are going to allow you to weaponize your defense. Because even when you are in a defense, someone made a choice. They chose you. So become a mutual combatant and choose to fight. Because they are starting the fight, they're giving you a location, they're sending you the contract. Accept the contract. And a lot of times what they don't want is someone that will fight back, which is why they're sending you the contract, because they're expecting you to just say, you know what, I want to step aside. Let me step aside. I'm going to give you this money so I can step aside, which allows them to look bigger than what they are, which is why they don't like trials. But I get in, again, things that I'll get into, because now, if you've been with me any time, now you're starting to see a lot of the things that I was saying 6-7 years ago now are starting to come together and make a little bit of sense to you, because these things are done with a purpose. I'm moving with actual purpose and in unison of what needs to be done to make sure you are winning. Now, the biggest challenge is the rare significance where instances where these decisions were overturned. Now, a lot of times when you're looking at them, it's staying fresh with mostly the newer Supreme Court rulings, or even understanding the Supreme Court rulings. Because just to give you an example, everybody was up in arms, oh, Roe v. Wade was overturned, Roe v. Wade. Actually, a portion of Roe v. Wade was overturned, but the context of what was happening, most people miss, because they say, oh, we're not going to use the word AB. We're going to call it something else. Why? Because on the exact same date of the ruling of Roe v. Wade, there was this Georgia ruling that was over here. It was originally filed as Georgia v. Doe. It was later filed or decided on the same day as Roe v. Wade as Georgia v. Bearden. And it gave you the actual criteria for where the abortion is, or the AB is allowed. And these things are still in existence, and those things have never been overturned, because most people don't know it exists, because the one that has the commerciality to it is Roe v. Wade. Now, when you go into the context of, just like I spoke about Terry v. Ohio, most people don't understand there were several layers of decision that was done in that case. And when you're going through that, that's how you're getting these clearly established, because it's been set and now that's been followed. And then the most important part is, when you have a state statute, it has to correlate with federal statutes and Supreme Court rulings. So if you have a state court statute that does not correlate, it does not follow legal precedent. So if there's someone enforcing it, it is now an illegal act. Why? Because of legal precedent. These are the things that you actually have to understand whenever you're doing the context of it. Because without understanding the ongoing debates of what's overturning and what's reestablished, literally whenever you're going to certain cases, people say, oh, that was overturned. No, most of the time it's portions of that ruling that were either clarified, or the ruling itself was completely overturned. Seldom is the ruling itself completely overturned, because most rulings have levels to them, or have several different components to them. Because even, I want to say it's a California case. As a matter of fact, it's 2 California cases where they talked about the curtilage. The next case seemed to overturn, I believe it was California v. Berlin. The next case, California v. Homel or something like that, actually gave you a definition of what the curtilage is. So it seemed that the first one was overturned, when in fact, no, it just gave you a definition. It used that one, said, no, we're not going to use it in the vague sense. This is the sense that we're going to use it. So now it gave a definition for the first one. And again, it's things that go in coercion with one another, and then you're able to use it as legal precedent, which now you can use it to step forth and go into your appellate courts, going into your rehearings or retrials, even going into your habeas corpus hearings. Now, when you're moving it, because all of this is strategic, no matter what you're doing, you have to, one, know your opponent, but you also have to know your destination. What is it that you're looking for? And then three, you have to actually know your situation, because the devil is in the details. These things are the things where some people are giving too much information, where in fact, all you need to know is who did the violation, what made the violation, and what your remedy of it is. The who, what, when, where, why, and how. All of that is set up in your complaints, but it has to be done properly. Now, what it does, a lot of people look at adoptability when they're looking at these cases, because they don't look at them as unison or connected. They look at them as individual separate cases, where in fact, all of them have several different components that are tied to multiple other cases. And I actually found that out whenever I started doing my studies, because again, Terryville, Ohio was a link between four other cases. And even when you go and do, what is it, Mills versus Washington, D.C., and it talks about roadblocks, four other cases pop up, and one of them is an Illinois case. One of them is a Chicago case. Another one is a Delaware case. All of these cases fall under Mills v. DC, and all of them deal with roadblocks on different levels. And that's why whenever I spoke about it, most people got like, hold on, that's not true. Well, yeah, go and look through each one of those cases. All three of them name each other. And they're using each other. Why? Because they're forming clarity, because it's only saying that you have the right to not be stopped, which again goes into Terryville, Ohio. While it seems innocuous and not part of what you're doing, it actually is the tie-in that lead to the legal precedents, which leads to the clearly established, which leads to the, well, you already know. Because I always tell people, understand moving forward is generally not often the same thing as getting the things that are necessary for going to federal court and establishing your case. Because a lot of times, like I said, we're looking at these cases as something that's separate, when in fact they are actually coherent and they're together. So just keep that in mind. And what we need to do is, when we're forcing equal protection, we're forcing fairness, because that's the true purpose of our alleged legal system. It is to promote fairness. And if you're going to give one this decision, this seems to be decision. This should be decision across the board, which is why our state system is vastly different from our federal system. And that's why our state system has such a trashy record, when our federal system is damn near unbeatable. Because if you violate a federal law, generally if you see them, it's too late. And a lot of people are finding that out now. But then they play the game on a completely different level. But again, you still have weapons at your disposal. It's just probably not going to be useful, because they're not going to show you their hand until they know they got you, which is the biggest difference. And 2025, let's take the idea of one thing I've actually spoke about, I want to say a little more than 6 months ago. Let's consider how we have the new AI currency, or AI that's working as our thinking or thought process now. We have cryptocurrency and testing existing precedents and force courts to apply old laws to new realities. These things are part of the new the new judicial process. When in fact, the biggest thing we need right now, and the biggest thing we're doing right now, is the ability not to only, I hate to say train our AI, because like I said, right now, it is trash because it's picking up all the wrong information. And even when it's gotten better, it's giving you the source of where this wrong information is coming from that they're using. But what it does is give you a direction in most times. But now, do you understand the question? Or I even looked it up yet. Do you understand the prompts necessary to get you to where you're going? Because that's what it's doing. It's still learning. And it's right now you have a baby. You have a 6-month-old actual baby that's learning. And it's one of those things, because even I speak about it with the iPhone, and I talk about it with a few of the other things that I do. It is something that's present. Even when I'm texting, I notice that it's the person, depending on the person I'm texting, it actually holds, certain verbiage or speech pattern that I have with that particular contact. Versus because to give you an example, it uses the nickname that I have for that person. Then when I speak to my son, it uses the nickname that I have for my son, but it also uses the verbiage. So I have a different tone that I speak with my son than I do with this other person. And both, it'll automatically just pop up. And even when I'm speaking with my brother, it automatically picks up on, oh, he's speaking to this guy. When he speaks to this guy, this is the tone he takes. And it's taken, I want to say, at least 6 months to actually get to where it's separating contacts and keeping long form and short form verbiage between those contacts and myself, which again, it's taking time. And as it takes this time, it's learning. And the only thing it's going to do is get better, I say, before we're actually able to have it doing what it's supposed to do. You're looking at about 3 years. But you can actually start forming things now and utilizing it not only in the court system, but in your everyday life. Because I'm actually doing a video called The Artificial Intelligence with the Application of Actual Intelligence. And these are the things that are being decided in our courtrooms right now. Because even you can't really say something that is AI generated is a copyright. When in fact, we have to understand how to actually use and explore and apply these things, because that's where the separation comes from. So thank you guys for tuning in. I'm going to be doing more shows. I'm probably going to have another one later on today. I'm going to set it up on the same timer, but I hope you guys keep tuning in, and don't forget, keep supporting the channel so we can keep going and keep growing. Supreme, and I'm out.